24th. Jamie sitting in for Charlie today. Thank you so much for doing that. And could you give a roll call?
Thank you, Marston. Happy to be here. Mayor Stone?
Here.
Mayor Pro Tem Zuniga?
Here.
Councilmember Elliott?
Here.
Councilmember Belto?
Present.
All right. Do we have any oral communications?
I currently have 1 phone speaker and 2 in person.
Okay.
This is the time for any citizen to comment on any item listed on the agenda only. Anyone wishing to address the legislative body is requested to submit a speaker card to the city clerk at or prior to speaking. Speakers are requested to keep their comments to no more than 3 minutes, and the use of visual aids will be included in the time limit. Time limits will be enforced equally as to remote and in-person speakers. And we will wait for the call to be transferred.
All right. Thank you very much.
You are now connected to the meeting. Please state your name for the record.
Excuse me, Jamie. Can we get her to start over?
Excuse me, Ms. Walton? Ms. Walton? Excuse me.
Please not vote for the change in the wording to Measure Q ballot measure as presented in the staff report for the special 2024-2020 City Council meeting at today's meeting. Neither the original ballot measure
The phone is disconnected.
All right. Why don't we go into the next speaker and we can come back to her?
or record
Oh.
the Measure Q ballot question to read as Attorney Briggs suggests on page 8 of 10 in the brief that I sent you last night and also this morning. There's a brief attached to my email that pertaining to the ballot lawsuit. And on page 8 it says, shall the measure to require that the city council to declare that the use of approximately 4.63 acres in Memorial Park is discontinued and abandoned, so that the property will be owned by the city in fee and can be sold or otherwise disposed of by the city in the same manner as it may dispose of other city property no longer required for municipal purposes be adopted. As Mr. Briggs states in his lawsuit, this statement is facially neutral, accurate, and less than the 75 word limit prescribed by Elections Code Section 303. Please consider using this new ballot question for measure in Q instead. Voters need to know what they are truly voting for, not what the city and council are anticipating may happen. Thank you very much. Have a good day.
Alrighty, up next we have Elliot Thompson, followed by Lois Sicking-Dieter.
Is this on? Okay. Good morning. My name is Elliot Thompson. I am a partner at the law firm Urban Cohen and Jessup. I represent the San Antonio Regional Hospital. I'm just basically here for any questions. I do want to, first of all, thank all of you. I know it's early. And thank you very much for calling this meeting. We reached out to the city and asked if we could maybe clarify this language just a little bit more, tighten it just a little bit more. So at our request, we wanted to come here and just have one last opportunity to just really make this language as clear as day, clear as possible. I'm not going to get into the merits of a lawsuit that are before the court, but I am here for any questions. If you do have any questions, I have been involved in this from the very beginning, and I can answer any questions, but I also don't need to step all over your very able city attorney either. So I'm just here this morning to answer any questions. Again, Elliot Thompson, and thank you so much for being here this morning. We really appreciate it.
Up next is Lois Sicking-Dieter.
Good morning. Honorable council members, my name is Lois Sicking-Dieter. I'm a 31-year resident of Upland and candidate for mayor of Upland. I am speaking in regards to ballot measure Q and how the question is written. The law requires the question be impartial and in language that is neither argumentative nor likely to create prejudice. Why are there such laws? Because in the past there have been cases where a poorly worded question was confusing and misleading about what a yes vote meant and what a no vote meant. This is so important that a resident's vote reflect their intention. For or against the measure. Measure Q question is confusing for many residents. This confusion is understandable because it comes from a flawed ballot statement that promises outcomes that are anything but certain. With this money, we may do this, we may do that. I was disappointed you didn't have the splash pad in there. Maybe you would do that. Furthermore, the way it is written currently and also the new revision will likely create a prejudice towards a yes vote. The lawsuit brought by Upland resident Mrs. Benesh defines this confusion rather well. Thank you, Mrs. Benesh. The lawsuit provides a question that appears to me to meet the letter of the law. I ask that you adopt this valid question that's in the lawsuit, not the one in the staff report. The true question should read, shall the measure to require the city to declare that the use of approximately 4.63 acres of Memorial Park is discontinued and abandoned so that the property will be owned by the city in fee and can be sold or otherwise disposed of by the city in the same manner as it may dispose of any other city property no longer required for municipal purposes be adopted. This statement is neutral and it's accurate. Thank you for this opportunity to share my comments. Lois Sicking-Dieter.
Up next, we have Steve Beerbaum.
Good morning, City Council. My name is Steve Beerbaum, Upland resident. My biggest concern here, I was kind of caught off guard with last minute notification on a Friday night about this special hearing. And I see that the lawsuit itself is not part of your package. At least it wasn't available online. And again, Mr. Flower, this is not against you at all, but I've stood up here a few times to discuss the inaccuracies, the legalese, if you will, about the lawyers in the legal firm of the current law firm adjusting the truth to fit your situation that works for you. And this, I don't know how much it costs. I don't know how much it costs to have him here. There were staff members and everybody at the last minute going, whoops, we got sued because the language sucked that you were trying to put in for an election regarding the sale of Memorial Park. That being said, I agree with what Lois has said about the language, because I did read the complaint. I'm sure you've all had a chance to get it and read it. And lawyers, no disrespect, lawyers are lawyers. One lawyer says one thing, another lawyer says another, but it seems pretty darn clear to me that the government code wasn't followed, or the language wasn't followed for this particular application. That's up to you. I stand here to still say that we, the city, under any circumstance, should not be putting this measure on the ballot for November. The way it was presented, the way that the average Upland citizen sees it is, the city is all for this, and that's not the case. You should not be involved. You representing us should not be involved in yip yip hooray. We encourage the sale of that portion of the park, because historically, that's not what some of you have been in favor of. You have been in favor of taking it to the citizens, but do it the right way. That's all I've ever said about anything. Just do it the right way. This is a correction to try to make it the right way. Thank you.
That concludes the speakers I have.
All right, thank you very much. All right, so we're going to move on to item number 3, and Stephen Flower, you're going to take it from here.
Thank you, Madam Mayor. Thank you, council members. Thank you all for being here, staff and the audience. Yes, this item, as the council is aware, concerns the now christened Measure Q, which concerns the potential discontinuance and abandonment of 4.63 acres of Memorial Park, and the question of putting that on the ballot. Last Tuesday, at fairly much the last minute, the city was served with a petition for writ of mandate and injunctive relief by a petitioner, the name of Marjorie Ganesh, alleging, among other things, certain defects in the language of the ballot measure for Measure Q. There is going to be a hearing on that matter for tomorrow at 1:30. Given that this is an election challenge, all of the timelines are kind of accelerated, and that's why this is all happening rather quickly. And I apologize, but that's just the nature of pre-election challenges. In response to this petition, the hospital requested that the council consider amending the ballot label language to hopefully move certain aspects of the petitioner's complaint. Now, to be clear, our office continues to believe that the existing ballot language measure is impartial and fairly describes the nature of the measure. And I would add, just from a legal interpretive perspective, we're not just talking about one provision of the code in isolation. The city has been following the statutes for disposition of parkland, which included early on in the process, in that resolution that you all adopted back in June, a statement regarding the disposition which the legislative body proposes to make of the park. So in the interest of full disclosure to the voters, that proposed disposition pursuant to the existing purchase agreement has been discussed throughout all staff reports, in the resolution, in the notices, in the ordinance, and in the measure itself, and now the ballot language. So again, I continue to believe that the existing ballot label is impartial and fairly describes the nature of the measure. However, there is this request from the hospital. It is recommended that you consider the request to change the ballot measure language as suggested in the staff reports. If the council wishes to grant that request, it can do so by adopting the draft ordinance that is in your packet. As with all election-related matters, that ordinance would go into effect immediately. One item to note is, given the briefing schedule here, with the hearing set for tomorrow, there is a chance that the court may give us alternative direction following that hearing, in which case we have a very short window to act, which may require the city to come back, or the council to come back on a special meeting to take further action. I alert you to that in the event that that happens. Again, we believe that the merits are on the side of the city at tomorrow's hearing, and that the city will prevail. But this is not the suggested revision that's before you today. I think would effectively move part of the legal challenge, at least as it pertains to the ballot label itself. That I am available for questions.
All right, does council have any questions? Councilmember Elliott?
I have a few, but I want to start with Government Code Section 36934. I have copies for each of our council members here. And it states, here you go, Rudy. Ordinances shall not be passed within 5 days of their introduction or at other than a regular meeting or an adjourned regular meeting. However, an urgency ordinance which pertains to public health may be passed immediately upon introduction and either at a regular or special meeting. Steve Flowers, are we even allowed to pass an ordinance or approve an ordinance at this specially called meeting?
Yes.
Under what provision of the government code?
I don't have the citation available, but there is a separate citation, there's a separate provision in the government code that lists specifically ordinances that can take place, that can take effect immediately upon adoption without second reading. there's about 5 categories of subjects for ordinances that can take effect immediately. One, as you say, are ordinances that are needed on an urgency basis to protect public health and safety. Others are election-related ordinances. There's provision for street improvements. But the bottom line is there's 5 categories of ordinances that can be enacted on an urgency basis, as well as provisions in the planning code that allow for interim ordinances in a moratorium to take place immediately upon adoption. Nowhere is the phrase urgency ordinance as it's stated in section 36934 specifically called out and defined. So there is a category of ordinances which can take place immediately, and in this context, it's an election-related ordinance which needs to take effect immediately in order to have the election take place. That is an urgent need, and in my opinion, makes this ordinance effective immediately if it's adopted today.
Okay, well, I'm not a lawyer. It just seemed to me that the clear language on this thing doesn't say except as otherwise noted in section blah, blah, blah.
And it doesn't, and I commend you for spotting the issue. It is something that I raised as a concern and was thinking through as of last Thursday. And upon further research, there is no provision that expressly spells out what is an urgency ordinance. So we're left with these other statutes which allow ordinances to take effect immediately under certain circumstances which constitute urgent need.
Okay,
Councilmember Elliott, I believe it's California Government Code section 25123
25123.
A. And it says all ordinances shall become effective 30 days from the date of final passage, except the following ordinances, which shall take effect immediately. A. Those calling or otherwise relating to an election.
Okay, that talks about when it takes effect. Section 36934 is when they're allowed to be passed. That's a different subject. The section 36934 says they may not be passed at a special meeting. They have to be either at a regular meeting or an adjourned regular meeting. And it's real clear language. So I'm not
Right.
disputing on when it should be, when it's taking effect. I'm talking about when you can actually even pass an ordinance. And it seems to me with the late 8 o'clock Friday night notice and a 7:30 in the morning meeting that this is something that this ordinance, this government code section is trying to address, is having ordinances just slip in there.
That is certainly on its face a reasonable reading of this statute. I would say this: when confronted with the real world, the principles of legal construction guide us to try to harmonize statutes as best we can. When faced with an election situation with short deadlines for both reviewing ballot label language, challenging that language, and potentially having to correct that language in order to make sure that the voters can have a say on matters of public importance, one must read these statutes to harmonize them, to realize that this is an urgent need for council action, and therefore can take place at a special meeting and ordinance can go into effect immediately.
Okay, well, I'm not gonna argue. Another question I have for Steve Flowers: does the Surplus Land Act apply to the sale of this baseball diamond? Do we
No.
have to put it through the process that is outlined on the brief here that I passed out to everybody? This was the petitioner's opening merits brief, and it talks about the process that cities need to go through on page 5. It says, when an ordinance becomes effective, the land described is deemed held by the city in fee. The city may sell or otherwise dispose of the property in the same manner as it may dispose of other city property no longer required for municipal purposes, according to Government Code Section 38460. In other words, voter approval does nothing more than entitle the city to dispose of that 4+ acres of Memorial Park in the same way it would dispose of any other land that it owned in fee but no longer needed. Going on, it talks about the Surplus Land Act and how one has to, a city, and we've gone through this fairly recently, so I'm somewhat familiar with this, that it has to be provided, there's like certain, like, low-income housing and, parks, and and schools are allowed first rights of refusal, basically, before then it can go out for a bid. So that doesn't apply to this, this comes under a completely different code section?
That's correct.
Okay,
Just to expound upon that answer, there are multiple different statutory provisions that govern the disposition of government property. The Surplus Land Act is a more general provision than the one under which the city is proceeding. The one under which the city is proceeding is specific to the disposition of parkland, or of city parkland that's been dedicated to park purposes. As the more specific statute, it is the one that controls the system.
okay, so then the proposed wording basically says, shall the measure allow the city of Upland to abandon and discontinue the use of for park purposes of approximately 4.63 acres of Memorial Park, so it can be sold to San Antonio Regional Hospital, in order to add facilities and increase capacity for medical services for a price not less than $4.3 million that would be used solely for the public improvements to Memorial Park, which may include a new baseball field, additional public parking, landscaping, walking trails, and other new public amenities be adopted. Now, it sounds like that if this passes, that's what's gonna happen, but what this doesn't allude to at all is the process of going then to the planning commission and then to the city council for the purposes of reviewing whether or not this complies with our general plan and whether or not we want to change it to a different land use. And it implies that that process is going to be affirmative, which I find very difficult to, it doesn't, I mean, I know we have constraints as to how many words, but it kind of shows that if this passes, this is going to happen. But yet there's a major hurdle that needs to be surmounted prior to that happening, and this does not allude to it at all. And so I find that this is, in that regard, biased and argumentative. It's not impartial, because it does not really paint a true picture of what's going on. If this is true, if we are saying, hey, if this passes, then this is going to happen, then basically you are saying that it's a sham when we vote on the planning, the land use, and whether or not it complies with our general plan.
As you point out just initially, you are absolutely correct. The city is under a 75-word limit for the ballot label itself. That's just a matter of administrative convenience. You got to put a cutoff somewhere. Some measures are very, very long. This is not a terribly long measure, but still there's a lot of ideas that can encompass here. So not everything can be covered. It does not directly address squarely that there are these additional steps. However, it has been made clear throughout the public record of this matter continuously that council action is required for this transaction to close. There is nothing in this ballot label that says otherwise. And furthermore, in my own impartial analysis, which has been filed for this matter and which will be published in the voter information, it clearly states that further council actions would be required before any development or any exchange could go through. And those include the rezoning of the property and further environmental review. So not everything can be spelled out in this context of the single ballot label, but if you look at the totality of the record, the totality of the information that's being provided to the voters, that issue is being addressed.
Okay, well, I'm kind of in a conundrum on this because I voted no to place this before the voters anyway. I did not want the city to dispose of this land, no matter how we looked at it. And I felt that this land should be held in perpetuity, that parks are a very important part of our general plan, and the priority of keeping our parks, particularly in southern Upland, is critical. So now I'm being asked to vote whether or not we should amend an ordinance that the other council members have passed and I objected to. So I really don't know how to vote. It seems kind of chicken to abstain, but that's truly, I don't feel a yes vote works for me, and I don't feel a no vote works for me. A no means let's just stay with the original language. Well, that doesn't sit well by me, and a yes vote means, well, I'm okay with putting this new language on the ballot, and I'm not okay with it either. So I'm just gonna justify why I'm gonna abstain for this vote.
All right, any other council members? Councilmember Belton?
Mr. Flowers, if we do not even vote to amend it, you're confident that you believe that you will prevail. Is that correct?
Yes, although, and I'll always tell you, you know this, there's no guarantees in litigation, and I will say honestly that this helps the city's chances.
Okay. What language specifically makes it different? What language specifically?
There is language in the statutes that specify the form of the sentence for the ballot label, where they say the label shall be written as, shall the measure ... be approved, and you fill in the middle. So that is the key difference. And when drafting this in the original, there was, and trying to stay within the 75 word limit, that language got dropped out. And so
Shall got it dropped out?
shall the measure, whereas the current language says, in order to ... shall the city discontinue using. So it would be, shall the measure be approved, directing the city to discontinue. I mean, that's
It's just some more clarification.
it's attempting to comply with a strict reading of the form rather than just merely the substance of the requirements of the ballot language.
And so without that change, you're less confident. So what could the judge say? Could the judge say add the word shall?
Yes. And we'd be back here doing something very similar.
We'd have to come back.
This is where the timing of the election code requirements versus the requirements of the Brown Act and have the council act on some of these things is kind of great tension.
So one individual files an action to prevent the entire community from having the right to vote. In theory is what's happening here.
That could be the effect.
If one individual complains about a word.
The judge has to agree on it.
I'm speaking right now. So one person is creating this. Okay?
Yeah, we know nothing about the petitioner here, but it is a single individual listed as the petitioner.
Mayor Pro Tem Zuniga?
So can we, I don't understand why the city is throwing things out there like we may do this and we could do that and make it sound all fun and happy. That's not what we're here for. So if you got rid of all that, couldn't you fit shall in there?
Well,
Let's say the funds will be used for improvement, only be used for improvement of Memorial Park. We don't have to throw in what it may be used for, because none of us know what it's going to be used for. I would hope it getting updated baseball fields and that's what we're losing. But if we got rid of all that stuff at the end, you would be able to fit shall, correct? We don't need to sell this to the community. It's up to them to vote on what they want. We shouldn't be selling it or not selling it. We need to be just out of it. You know what I'm saying? I don't feel that we should be selling it to the community that, hey, this is a good idea to vote on this because we're going to do all this good stuff with it. should just be neutral.
There's no direct question there, but if you'd like me to respond, as I said, there are provisions in the government code governing the disposition of park property specifically that require the council to put out there the proposed uses for which the park land is going to be put. And part of the context of that is what the money would be used for. There is an existing purchase and sale agreement that governs what the purchase price can be used for, which is solely for improvements to Memorial Park. Now, the additional language regarding landscaping, public parking, trails, amenities are illustrative of what the purposes might be. It's not factually inaccurate. Just say that this is the things that which the money may be used for. I think that the key, it's not that dissimilar from the tax measure that the council consider or many other sales tax measures like that to specify the money is going to the general fund, here's what the general fund pays for. And so I'm not, you can go with less. I'm just telling you that this does not violate the elections code in my opinion because it's not inaccurate. And it's consistent with the entire record of this case going back to the original discussion of the purchase and sale. And so there was nothing additive here that hasn't been discussed at length in the record.
Okay, so, but by saying that would be solely used for the public improvements of Memorial Park, it would cover all those things, right? Like, they can cover a new baseball field and parking and landscape, like, that wording can cover all that. We don't have to go into that, what that blanket statement means, which would save us wording so we can add the word shall.
Well, regarding the shall issue, the proposed
Well, that's what the
ordinance
is.
addresses shall. So that's taken care of and we're under the limit. What you're saying is that you'd still, even though we inserted the word shall now, you'd like to take out basically the last 2.5 lines.
Well, I just don't feel that the city should be trying to sell this. It should be a decision on the community whether they want to vote yes or no, and there should be no one side trying to sway them or anything.
And that's a matter for the council's discretion at that point. From a legal perspective, this is not inaccurate. It's consistent with the record. It's also consistent with the language of the measure itself.
And now I'm talking about the existing, because I'm reading here where you say the city attorney continues to believe the existing ballot label is partially fair. And this is the second one, is what I'm reading. I'm not reading the one on top.
And I maintain that is accurate, and it is consistent with the language of the measure itself.
Also, just for clarification, what is this, your fees are being covered by who today?
This is all covered by the reimbursement agreement between the city and the hospital.
So the city is not covering anything today, right? On the land abandonment issue with land, I was told that if it goes to a ballot, that we don't have to, it doesn't hold the same grounds as abandoning as a piece of property. Like the right of way, you would have to abandon it and do all that stuff. If it goes to a ballot measure, it's automatically abandoned. Is that true?
It's an odd statute, the park statute. What it says, and this is tracked in the impartial analysis, is that if the voters approve the measure here, it is a direction to the city council to subsequently adopt an ordinance declaring the park abandoned for park purposes and discontinued. So there's yet another step. It's very strange compared to any other initiative measure. It's just the nature of the statute, the way it was written back when it was written. So what happens is the voters approve the measure, directing the city council to adopt an ordinance discontinuing and abandon the use of the land for park purposes. at which point the previously existing purchase and sale agreement kicks in. And if the hospital goes through the process of applying for a zone change, and council approves it, goes through that whole process, including the environmental analysis, then basically, and a few other closing conditions spelled out, the sale goes through. So that's the process.
Now, what's Monty, I don't know if you got the email with Corey Briggs, what they're asking to be put on the ballot.
Our office received his brief around 4 o'clock on Friday, which was about 4 hours past the court's deadline, so we didn't have a chance to incorporate or review any of that at the time that the staff report went out. We reviewed it since and preparing our response to the file this morning for. And I did, yes, to answer your question, I did see the language that's being proposed. It's basically very, very narrowly tracks the language of the statute without providing any sort of information about the broader issues or consequences of the action.
Okay. I kind of find it a little bit confusing, the way it's written up, but just, that's all I have.
Any other comments or questions? All right, so, this is confusing, and it is, I mean, it was brought on us at the last minute, but it wasn't because we neglected to move forward, it was just kind of dropped in our lap. And I think a lot of people have to understand the frustration to have a notification on Friday and try to research and then have a Monday morning meeting at 7:30. It's frustrating. So one thing I think what we need to do is we need real clarification, what we're voting for, how we're voting for it, and what the effect that it does. I read the packet. I understand it. It's confusing. I'm kind of miffed that it's one person that's causing all of this. I don't know if you want to call it drama or whatever over this issue. It's not a group of people. It's one individual. Correct?
Correct.
So I understand staff recommendations are to change the language as stated, correct?
The recommendation is for you to consider the ordinance.
Or the ordinance,
Which would, to address your question about what happens if you would take that action. If you approve this ordinance, it would change the measure of the ballot label and the ballot label only. The measure itself would be as it was originally approved. The arguments that have been submitted, pro and con, would remain unchanged. The city attorney's impartial analysis would remain unchanged. This is simply the ballot measure language, the ballot label as it appears in the ballot the voters will see. Obviously, we're all familiar with the fact that the measure language is often located elsewhere. But that remains unchanged. So that's the only change that would happen.
All right, so are there any other questions? So would anyone like to make a motion?
Is the motion to make the change to add the word shall?
That is kind of a bottom line summary of what the change in the ballot language is. The longer form question is it changes the language from what's in there now, in that first block of the staff report, to what's in the second block. So if you look at the staff report,
word shall in a different location. Basically, moved it from the front to the middle.
Yeah, the word, yes, and it added the words shall the measure.
Okay.
The words the measure do not expressly appear in the existing language. The word shall does, it's just,
Be adopted.
Yeah, we adopted.
and that adds about 4 or 5 words.
Probably because I understand what's going on, it probably doesn't affect the way I'm thinking one or the other, so I, because of what I've been through the whole process of what's being done, what's being offered, what is expected, but I don't know if it's gonna change anything. So if that's what it's gonna take to move this thing forward, then I'll make a motion. That we adopt the ordinance amending the ballot level for the city of Upland.
And I will second that. So,
Can I recommend that the motion include waiver of full reading?
Yes, waiver of full reading, yes.
An ordinance of the city of Upland amending the ballot label for the city of Upland park measure on the November 3rd, 2020 election ballot.
There's a motion and a second then?
yes.
I make a motion.
All right,
So
so
good.
we need to vote?
Yes.
All right. All right, so, we have Councilmember Elliott abstaining and, Bill losing against, vote yes. All right,
That is it, Madam Mayor.
thank you very much. Thank you all for attending this morning. We will adjourn and, we may be back sooner than September 14th, but hopefully we won't, so thank you.